All right, we call the two cases, 24 CR 79 and 25 CR 434, the state of Texas versus John Guillory, also known as John Guillory III. Is that you?
Yes, sir.
Okay. On the older one, this is 2.5 years old. You're charged with a third-degree felony of unlawful possession of a firearm by a felon, and okay, it's a habitual felon status, right?
That's my understanding, Judge.
We go back 1, 2, 3 convictions in 07. Thereafter, a conviction in 09. That was in 09, habitual felon status. To 10, escape conviction. And then in 22, a conviction next door out of 252nd. And then 25 CR 434.
Yeah.
Another unlawful possession of a firearm by a felon conviction, charge with 1, 2, 3, 5, 6 paragraphs of prior convictions. Actually, most of them are unlawful possessions of a firearm, and here you are charged with 2 unlawful possession of firearms. Are you represented by anybody, or are you representing yourself?
No, sir. When I came on January the 5th, I requested to proceed pro se, and I also filed a motion to be admonished to proceed pro se amongst other motions.
Okay, you can represent yourself.
Your Honor, if I may, I'd ask that the court consider appointing a shadow counsel in case there is a question.
Somebody will be appointed standby
Stand by. Yes,
if
sir.
necessary.
Okay. One other
He
thing.
can represent himself as
Yes,
long
sir.
as he wants to,
Yes,
as
sir.
long as he follows the rules. And
Yes, sir.
and
I don't
but
know.
I'll appoint somebody as sit with him so he can confer if necessary.
Yes, sir. One other thing, I'm sure the court has admonished the defendant about the habitual offender status. The state would also be seeking.
I'm sure I did, because we've been up here before. He knows he's looking at a minimum of 25 years confinement in prison if he's found guilty of all of this, up to life imprisonment.
One other
And
thing.
probation is not an option.
And one other thing, Judge, the state would be seeking to accumulate or file a motion to stack these sentences as well, Judge. I don't know if there's an admonishment the court would want to give on that as well.
Well, you can talk, you can direct him. He's listening, and yeah, he's going to represent himself, so you can speak to him directly, and
Yes, sir.
you hear whatever you got. It's a most recent sentence according to this in 22. 22. What were you sentenced to out of that court next door?
I showed 3 years on that BOCS, Judge.
Well, he's done that. That was in 22. He's completed that, hasn't he? Is that right? You've completed that sentence? Okay. So what is the sentence you're talking about that would be stacked?
I am showing 2 pending unlawful possession of a firearm cases, Judge. One in cause number ending in 0079, the other one in cause number ending in
From which,
434.
where, what court?
The two
This court.
we have right now.
Yes, Judge.
He got one while I'm on, but that's fine.
Oh, okay. So you're talking about, you're going to request that 24 CR 79 and 25 CR 434, if he is convicted of these 2 offenses, those sentences be stacked.
Correct, Judge.
Okay. I didn't know if there was some other jurisdiction out there that he had another. Okay, so we're all here. Okay.
You know, I like to object to those indictments. In 24 DCCR 0079, there was no warrant for the seizure of my person, and there was no exigent circumstances or reasonable suspicion. I was a passenger in a regular routine traffic stop. There was no reasonable suspicion. I was armed and dangerous to the officer. There was no probable cause to go beyond a
All
traffic
right, you can
citation.
bring that up at trial.
You know, I filed a motion to suppress the evidence which should be in.
Yeah, I reviewed those. Anything
And-
else you want to add on them?
Sir,
Anything else you want to add to those?
not to the motion to suppress. I
Okay.
just asked that the court consider the motion to
There, I
suppress.
considered them. Yeah,
Yes, sir. And-
they're going to be denied, but it's something that you could appeal later if you have to.
Okay, so the motion to suppress is denied, Your Honor?
It is. They are.
May I have
else?
the grounds? that-
No.
Okay.
Insufficient
Yes.
evidence presented to support the motion.
Okay, and in the other charge, I have two affidavits that I would like the court to consider and take judicial notice of.
For what?
You know, for the firearm that was found in the car.
You can bring that you can bring up at trial. But remember, the rules of evidence are what they are.
Yes,
I was
Your
on
Honor.
the I was on the evidence committee that was
already on file, and I'm just asking that the court consider them.
okay. Just follow the rules of evidence and the code of criminal procedure, like all others are supposed to. You're going to be held accountable for that. That's the problem in self-representation is too often that does not happen. But I was on the rules of evidence committee that wrote the rules of evidence, and I'm sensitive about following it. But just follow it. And, then you'll have a chance to be heard, and then we'll let the jury decide. When can we? When is this set for?
Yeah, we had removed it off the trial docket.
It needs to get off.
Judge, also, could I receive the order so that I could appeal the pretrial denial of?
No, their orders are on the record.
Okay, so I could just file my notice to appeal? That,
He didn't do.
Yeah, but you got to order it through the court reporter. I'm not going to tell you how to do that. You're representing yourself. That's your business. But it's oral orders and they're in the record. They're made. Yeah. Anything else?
Nothing from the state, Judge. Thank you.
What's the date we've got this thing set?
Judge, I'm ready whenever we don't try
Do
down.
you have an idea? So we can all know to get ready. What's the date on his indictments? The earliest one?
1/24/24.
Okay, that's 2.5 years. Yeah. Accelerate it.
17th of August.
August 17th. How's that?
the 17th, that's fine, Your Honor.
Good.
Thanks, Judge.
Judge, I also requested discovery. I don't have any information pertaining to my case.
I will make a note, and I'm happy to make it available, Judge. Because of this pro se situation, I'm going to have to work through the logistics, but I represent to the court that I'll make it happen.
Okay. I'm not sure what wouldn't be disclosable. I mean, that's kind of open file on this.
That's what I'm thinking. Yes.
On
Bring him over to
unlawful
jail because we don't want
possession
that
of a
material.
firearm.
We don't want that material in the
Yeah,
jail.
let him look at it, and if you need copies of things, give
Well,
it to him.
my understanding is they don't like copies of that stuff over at the
Yeah,
jail.
they're not allowed to have it.
That's what I told him.
Well, what does he do?
Come over and view it in person.
Well, he can make his own notes. What about that?
Yes, sir.
Yes,
Well, isn't that like a copy?
they just can't bring the discovery to the jail.
Oh, you're saying they don't want to
Yeah.
discover? Okay.
He has to come here and go through stuff.
That's my understanding,
Yeah.
Judge.
Well, hold on. So he can come over here. Can we make copies of him here and give it to him?
The district attorney's office will provide all the discovery to him and then
Is that-
have him sign off on it.
How-
Some
still-
other people.
Okay, hold on. There are two ways. He can either write all this stuff down that you're going to give him, or can you make copies for him?
Judge, that's the logistics I need to work through. My understanding is the jail does not like for those defendants to have copies, actual copies over there.
Why not? I don't know.
Shut him, toilet, back everything.
Well, and even more than that, I think there's other issues, Judge, about having that information floating around out there, which is with names of witnesses and addresses and, that kind of thing.
You're not worried about lawyers having all that information?
That may be an issue as well, Judge, but as far as the instant case, we'll work through the logistics.
Okay, but see, here's the deal: is he can write it down. He can write all that stuff down and carry it with him. I don't know what the difference is if he writes verbatim. He's got a duplicate copy of it, and how do we explain? Well, you can't have the regular copy, but you can make a duplicate copy yourself, and you can carry it with you.
Just trying to follow the rules, Judge.
Well,
I'm a rule follower.
I know, but I always thought rules had to make sense too, so to enhance people to follow.
Excuse me, Your Honor. And also, just for clarification, is that all the motions that I filed, are all of them denied?
Yeah, Yeah. What other ones do you want to bring up? Yeah, I'm not going to tell you how to do your job, but you just don't file motions. There's you have to present them in a way that meets the law. I'm not going to tell you how to do that. You've decided to represent yourself. It's not my burden to come forward.
I understand, y'all.
Anything else you want to say?
Evidentiary hearing?
No, we're going to have an evidentiary hearing at the trial.
Okay.
Anything else?
Nothing from the state judge.
That is all. You're in this.
Rest.
Anything else? Any other cases?